And hello there once again. Welcome to In Your Corner. John Scholes, Sivan, Tumarkin, James Fireman. We are all here and ready to go. 1-855-821-5900 anytime to reach out. And it is help at inyourcorner.ca. Sivan, I know you got a week that was a success story on the way. And a little later on, we're going to get to the 5 things you must do ASAP if your LTD benefits are about to be cut off. Stick around for that. But James, what do you got to say today?
Well, I'd like to start off the show by talking about mental health claims. So we're talking about depression, anxiety, post-traumatic stress disorders, and things of that nature. There is a perception that mental health claims are not as strong long-term disability claims as a physically based claim. And I really want to spend a few minutes talking about that because it's simply not true. So this perception comes from a few things. It comes from a stigma about mental health issues that has existed for many, many years. And to a large extent, I think as a society, we're better educated about these issues. It's certainly not gone. There's still a stigma there, but things are moving in the right direction. People understand more about these issues now than they did 5, 10 years ago, that's for sure. Another reason for it is how these cases have traditionally been treated in the courts and by insurance companies. But the reality is today, in my view, a mental health claim for long-term disability is as strong and in many cases stronger than physical claims, and it's for a few reasons. So number one, it was just 2 years ago, the Supreme Court of Canada had a decision in a case where they made very clear that mental health claims have to be treated the same as claims for physical disabilities. You cannot make the test harder for mental health claims than you do for physical disabilities. So that's number one. The courts are recognizing that there has to be equal treatment for these types of claims. But number two is the way most long-term disability policies are worded. It allows for the first 2 years, you get your benefits if you are not able to do your own occupation. But beyond the first 2 years, you're entitled to your benefits only if you can't do any occupation. It is a tougher test. Yep. Now, if you have a physical disability, in many cases, after 2 years, even though you can't return to the job that you had, there may well be another job that you can do. But if you have a significant mental health issue, you're suffering from severe depression, anxiety, PTSD, that follows you around 24 hours a day. And if it is a significant enough issue, there isn't a job that you're going to be able to do. It's that simple. And so the reality is mental health claims are in many cases stronger than physical claims.
Is it just the fact that you can't see them on an X-ray? That's where the argument lies some of the time?
Well, traditionally, yes, that has been an issue, but there is a line of cases that have gone through the courts that have said, no, it does not matter. A lot of times we'll hear insurance companies reject a claim, and they'll say things like, well, there isn't objective medical evidence. Well, that's not in the policy. If you take a look in the policy, there is nothing that says you have to have an objective medical document that shows, in black and white that this is what you're suffering from. You do not need an X-ray to show that you are suffering from a disability. And this isn't my opinion. This is the opinion of the Supreme Court of Canada. And because of that, I think you can rely on it.
1-855-821-5900 and help at inyourcorner.ca to reach out through email. We'll get to one here in just a couple minutes. What do you got going on, pal?
John, I had a gentleman call me this week, 51 years old. His name is Jim, and he's a mechanic. And a few years ago, he was involved in a terrible accident, and he suffered what many of his doctors think is a concussion that had long-term effects. And so he goes on short-term disability, and then he applies for long-term disability and gets denied. And why does he get denied? Well, here's background for you. Even though he suffered a concussion, the opinions of the doctors that he has been seeing, that he saw, are mixed. Some of them think that there is an organic cause, meaning that his brain was actually damaged because of the accident. Some of them think that whatever damage he had, organic damage, actual damage to the part of the brain that is controlling motor functions and everything else he has, they think that that's been repaired, and what he's been left with is the psychological trauma, PTSD. Okay, PTSD and a few of other things. So some doctors think it's psychologically based impairments, and some of them think that it's organically based. And so what the insurance company's position is that because there is no formal diagnosis, or because there is a diagnosis, but there is a mix of opinions on what exactly is the root cause of his impairment, because of that, they have denied his claim. Now, keep in mind, none of the doctors that he has seen, none of them say he can go back to work. They're all in agreement that he is disabled from working. And we have seen this before where insurance companies take the position that because there is no solid diagnosis or because the doctors can't figure out exactly what is the name of the problem that you're having, they agree that there is an impairment, but they can't figure out what exactly is the nomenclature of the issue. Because of that, they're denying your claim. Insurance policies don't work that way, disability policies. There's nothing in them that says you have to have this kind of impairment or that you have to have a specific diagnosis in order to qualify. The test is, as James outlined, can you do your own occupation for the first 2 years? Can you do any occupation beyond the 2-year mark for which you have training, education, or experience? As long as the doctors, your treating doctors, are saying that you are impaired from working, you should qualify for a disability. And you know, you can put the adjuster's feet to the fire by saying, show me where in the policy it says that I have to have an actual diagnosis. Where does it actually say in the policy that the doctor has to say it has to be an organic cause or it has to be a psychological cause or whatever? So again, we see this time in and time out. We see insurance companies deny legitimate claims, and people are left to, you know, they're left out to, you know, to dry. And they call us. We look at the policies. We look at the medical documents. And we are just absolutely at a loss as to why the insurance company took the position they did. The only explanation is, as James has said, they're in the business of making money. And one of the ways to make money is to deny claims, even claims that are legitimate.
You know, I was actually just a moment ago talking about that case that the Supreme Court decided that said that you have to treat mental health claims the same as physical claims. The very same case says clear as can be that the analysis is not on the diagnosis. You do not need a formal diagnosis. The analysis is on the symptoms.
Right.
That is what you have to look at. And that makes sense.
Yeah, we don't know everything about the human body. We haven't cured everything.
Medical science progresses year over year. And so 10 years from now, we're going to understand what the underlying cause is of many things that we can't put a label on or explain right now. But that doesn't mean that today you're not entitled to benefits. The issue is only whether or not you can do your own occupation or down the road any occupation. It is not about has the medical community come together and all agreed that this is the label we're putting on it. That's ridiculous. The issue is just on whether you can function in the workplace. That's it.
Help@inyourcorner.ca. That is the email address you want to send one along. Would love to hear from you on this show or shows to follow. From Laurel writes in, says, my niece has MS. She's 37 and worked for over 10 years until her illness got worse. She's been on LTD for over a year and a half now. The insurance company had her see one of their doctors who said that she can do other work. She is physically unable to work and has difficulty functioning even at home. What should she do if her insurer decides to cut her off her disability claim?
Well, the first thing I'm going to point out is if they've spent the money, if the insurance company has spent the money out of their pocket to send Laurel's niece to see their own doctor, that is what they're gearing up to do. Make no doubt about that. Because if they are spending money, that means that they think that there is going to be a financial benefit to them down the road. And what's that benefit going to be? It's going to be cutting off your benefits. That's how they make money. Cutting off your benefits, taking in more premiums. So yeah, I agree. I think that is probably coming. Whether or not that opinion is going to sway anybody in the legal system if we bring a legal claim is a whole other story. Now, I will say that it's not every case we see that the insurance company actually goes even that far to hire a doctor to actually do an in-person assessment. More often than not, we see them do things like hire a doctor to just do a paper review of the file, and sometimes not even that. Sometimes it's hire a medical specialist to review the file, and sometimes not even that. Sometimes they'll just cherry pick things from what they get from your clinical notes and records of your family doctor and use that to justify their decision. So I will say in this case, the insurance company has gone farther than we typically see, but that doesn't mean that their doctor's opinion is the final say, because the reality is a treating doctor's opinion, the person that you go to for treatment day in and day out, year over year, is almost always going to be preferred to someone who has seen you on one occasion for an assessment, especially where that person is paid by an insurance company, and even more so when that is a significant portion of their business. And I'll tell you this, if this case were to ever go to trial, if we were to start a legal claim and we weren't able to resolve it, and I went to trial, and I was cross-examining this doctor, I'm going to find out pretty quickly how many files he's gotten from this insurance company over the years and what portion of his income that makes up. And I don't have to say you're biased because of it. The implication is there, and it's well understood. So even if this doctor is doing what they can to be fair and balanced, if they are getting a significant portion of their income from an insurance company, their opinion is not going to matter nearly as much as a treating doctor.
One thing that Laurel's niece may want to do is obviously advise her doctors that she's going to see the insurance doctor, and after she sees the insurance doctor, request a copy of the report from the insurance company, get that to your doctors, have them review it, because I'll tell you, John, more often than not, the treating doctors are going to go through the reports of the doctors hired by the insurance company, and they're going to be able to pick out all of the problems, all of the factual inaccuracies. They're going to pick out the wrong diagnoses, the wrong recommendations. They're going to pick out everything. And you need that because you need your treating doctors to be on your side so that if there is a rebuttal that's required, they can provide that. And at the end of the day, chances are, if this ever ends up in court, and again, we talk about court sometimes, but the vast majority of these cases never, ever get to court because insurance companies do not take that risk. They want to settle these cases. But if it ever went to court, who do you think a judge is going to side with? Is he going to side, or is she going to side with the doctors hired by the insurance company who may or may not have seen you? And if they've seen you once, or are they going to side with you and your treating doctors who've been treating you for months, if not years? It's just logic. Insurance companies know that.
Coming up here, the 5 things you must do ASAP if your LTD benefits are about to be cut off. Stick around for that. 1-855-821-5900 and help at inyourcorner.ca to send us along an email. More In Your Corner is on the way. Hang on.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-855-821-5900, or go to inyourcorner.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back to In Your Corner. You want to reach out, the phone number is simple, 1-855-821-5900. Email address is help at inyourcorner.ca. More emails coming up here, but first we will get to this, guys. The 5 things you must do ASAP if your LTD benefits are about to be cut off. Number 1, I'll throw this one to you, Sivan, first. Check your LTD policy to determine at what age your benefits are supposed to expire.
That's absolutely critical, and I'll tell you why, John. So many times I've had people contact me because they're saying that, something doesn't make sense here. You guys talk about age 65, which is when most of these policies expire, and yet my insurance company is telling me that I've been on it for 2 years and that's it. I'm not getting any more.
Yeah, 39.
39, I'm 25, 58, whatever the age is, people are under the impression, or this is what they're getting at least from a messaging standpoint from the insurance company, that their benefits are only there for 2 years. Now listen, there are some policies out there that are time-limited policies. Sometimes you have a policy that may take you for 2 years, 3 years, 5 years. Some of them may take you beyond age 65. The vast majority of LTD policies out there will take you up to age 65 if you meet the criteria for long-term disability beyond that 2-year mark if you're not 63 years old. Right. So the point is this. If you've been on disability for 1.5 years or a year or 2 years, whatever it is, and the insurance company says that's it, at a particular time, a particular date, your benefits will expire, find out why. And if they tell you, well, because that's it, you're no longer eligible, we need to understand the reason. Don't simply assume that the actual policy expires in 2 years or 3 years or 5 years. Your policy will state explicitly until what age they will pay you, assuming you meet the criteria. That is absolutely crucial, John. I can't tell you how many times people have been on the verge of walking away from literally hundreds of thousands of dollars that's been owed to them because they've assumed that their policy was a 2-year policy. By the way, I've never seen a 2-year policy. Okay? I simply have heard from other lawyers that they've seen those, but they are very rare. So that's why I'm saying be very, very careful walking away thinking that you only have a policy that will take you, that will give you LTD for 2 years or 3 years. Again, assuming you are disabled from working for the first 2 years and then for any occupation beyond 2 years.
We are going through the 5 things you must do ASAP if your LTD benefits are about to be cut off. Number 2, James, for you, says if you're unable to work, get your doctor or doctors to confirm in writing that you are still disabled and explain why you can't go back to work at the present time.
I can tell you that there's one question that I get from every single person that I talk to about long-term disability claims. They always want to know, do you think I have a good claim? Which makes sense. And the answer almost always hinges on one variable. Do you have the support of your treating doctors? Do your treating doctors believe that you are unable to return to work? And if the answer is yes, then in almost every case you are going to have a good claim if your insurance company has denied or cut off your benefits. So you want to go to your doctor and make sure you are certain that they agree with the fact that you can't continue working. And if they do, you want to make sure that they put that in writing. Now, it's really important that they understand what your job is actually about. They may know, broadly speaking, what you do, what your job is, but every job at every employer has different variations and may involve different physical requirements and so on and so forth. So it's important when you go through this process that you make sure your doctor understands what it is that you do on a day-to-day basis and is going to give you a written document that says you are not able to do this job. And it's important that they relate it to what the requirements are of your job. Now, even if you have a completely sedentary job, it's still very critical that you get that opinion from your doctor. And there are going to be many cases where your doctor is still going to be able to relate that. From a physical perspective, for example, let's say you have a severe back injury that prevents you from sitting more than 10 or 15 minutes at a time, and I've seen this in many cases. You can't do even a sedentary job if every 10 or 15 minutes you have to get up. There's no way to function in an 8-hour day, 5 days a week, if that's what your reality is. And as I've talked about already twice on this show, if you have a mental health claim, if it's severe enough, it's going to be impossible for you to show up to work and function day in and day out, 5 days a week, 8 hours a day. It's just not going to happen. So it's important that your doctor relate what your disabilities are to the requirements of your job, put that in writing, and then ensure that the insurance company has that in their records so they cannot take the position that there isn't enough medical documentation.
One peripheral point that I want to make, John, is that we have people referred to us sometimes by doctors. Be they family doctors, psychologists, various specialists, chiropractors. And so to doctors out there, if you have questions, you are dealing with a long-term disability situation with one of your patients, feel free to call us, feel free to email us, have your assistant, your secretary call us or email us. This information is free. And it does happen. I've had doctors who say, listen, this is what I'm being asked by the insurance company. What do you think? So long as they have the permission of their patients, which I know they're very careful about to make sure that the patients understand and they know that the doctors are contacting us, we will be more than happy at no cost to help your doctor fill out the paperwork to tell them exactly how things should be worded. And we've done that before. And again, there's absolutely no cost to this. At the end of the day, it's a service to individuals out there because we do find sometimes the doctors mean well, but they don't necessarily interpret the questions being asked of them by the insurance company the way that insurance companies intended the questions to be asked. So again, our job is not only to educate, but to help people out there, including doctors.
Number 3 on our list of things you must do ASAP if your LTD benefits are about to be cut off. If you haven't done so already, apply for CPP Disability.
So that's very important as well. There are various reasons why we think people should apply for CPP Disability if, in fact, they are disabled. Remember, the test for CPP disability is different than for long-term disability. It's actually harder to get CPP disability. Your disability has to be severe and prolonged. It is a different test, but it gives you advantages if you apply for CPP disability. And really, there are two advantages. Number one, if you apply for CPP disability and you get accepted for it, it's going to give the insurance company less of an excuse to cut you off, I would say, okay? Because now there is a governmental body that has deemed you disabled. We've still seen people who've been qualified for CPP disability, which is a harder test to meet, and they still get cut off. But it does help you with your legal case. Number two, in the event that you're cut off long-term disability, and we fight the insurance company, CPP disability is a separate income source. You're going to get that. Now, again, I have people contacting me saying, okay, I'm getting LTD, and now I've been approved for CPP disability, but my LTD insurer is getting a credit for that, meaning I'm not getting LTD plus whatever I qualified for CPP disability. And that's just a function of the way long-term disability works.
Usually.
Usually, you're right, usually. Insurance companies will often tell you apply for CPP disability because generally we see provisions in LTD policies that say that they get a credit for it. But again, there is an advantage in you applying, and it's something that we do encourage our clients to do, and it does help your legal claim and it does protect you from a money source standpoint.
We're talking the 5 things you must do ASAP if your LTD benefits are about to be cut off. Number 4 on the list is confirm in writing to your adjuster that you are not ready to go back to work and that your doctors have also said that you're not ready to go back to work.
Okay, so there is something that I see in, I won't say every file, but I see this repeatedly when I get the insurance file and I'm taking a look at the point in time where the insurance company has made their decision that they are going to cut off benefits. And typically what they will do is they will call the client and say, we've made this decision, your benefits are going to end on such and such a date, and so we're going to start a gradual return to work program. Maybe there's a work hardening program first, but this is what we're going to do. And the phone call, I call this the steamroller approach. So the phone call goes something like this. Hi, how are you doing? We've decided we're going to cut off your benefits, and we've got this return to work program, okay? And the client's just sitting there like,
What?
Okay. And then you look at the notes, and the notes say, client says okay. Client is prepared to go back to work.
Ouch.
They've just steamrolled you into your agreement that you're going to go back to work. So you want to make sure that if you do not believe you're ready to go back to work, and if you're calling us, you probably don't. If you don't believe you're ready to go back to work, you want to make sure that is absolutely clear. There is no ambiguity whatsoever that you do not agree that you are ready to go back to work, you are not prepared to go through the gradual return to work, and that you don't feel like you can go to the work hardening program, if each of those are the case. It may well be that part of that is agreeable to you. You may be prepared to do the work hardening program if your doctor thinks it's a good idea. And if that's the case, so be it. But you make sure that regardless of what happened in that conversation, that you follow that up with an email to the adjuster, so it is in writing, making absolutely clear that you do not feel that you are ready to go back to work, so that they can't put words into your mouth.
5th and final thing you must do ASAP if your LTD benefits are about to be cut off, contact you guys immediately. Do not wait. And the old A word, do not appeal. Do not appeal.
Do not appeal.
Yep.
Absolutely do not do that. If you do, you are at risk of prolonging the agony, of taking a very, very long detour into the conclusion of your case. And we tell people to contact us because we talk to people every single day. And it's not just by phone, it's via email, it's any type of correspondence. We give information out and it is free. And if you do not call us, at least call someone with a focus and a specialty in this area of law. It's your money. It's money that's owed to you by the insurance company, to you and your family. And so, John, we tell people, give us a call, contact us. This is all we do. There's other lawyers at the firm that do employment law. Our group only does disability law, injury law, and we know this area inside and out. And again, our goal is to help people, to help their families, or at the very least to tell you, do you have a case or do you not? We don't tell everyone that calls us that they have a case, but we will tell you the truth. We will tell you what your options are. We will tell you what exactly to expect, and then you make the decision, you and your family. And if you choose to proceed, that's great. If you choose not to proceed, that is great too. That is a choice you've made now that you've been informed.
Email address is help@inyourcorner.ca. Archie writes in here, says, my brother works for a bank and has been struggling with mental health issues like depression and anxiety. He sees a psychologist regularly and is on medication, but his condition has worsened in the past few months. While he was in the process of going on sick leave, he was let go. Should he apply for LTD? Does he even have LTD coverage now?
So absolutely he should apply for LTD, and he almost certainly does have coverage. There was a very recent case that spoke to almost exactly this issue. And so the way the analysis works is if you had the disability while you were still employed, or even through the severance period, you are going to continue to have that long-term disability coverage. And so what Archie has said is that his brother was in the process of applying for disability when he was let go. So almost certainly he is going to have the coverage. And even if he applies and the insurance company says, oh no, sorry, you weren't covered, there's a very strong argument that in fact he was. And so certainly we could start a legal claim if they denied on that basis. There's also another issue here though, in that his employer let him go while he was obviously disabled. And so that certainly brings up the issue of whether or not he was properly compensated in his severance, because if you let someone go while they are disabled, that raises a specter of human rights damages. And that's really significant when you're also dealing with a long-term disability claim, because anything you get for human rights damages cannot be deducted from your long-term disability benefits. But your severance, in almost all cases, not all, but in almost all cases, it can be. So it's critical that whoever you have representing you understands the issues, not just from the disability side, but also from the employment side, and vice versa, depending on which is coming first.
We'll take a short break, guys. How to deal with an adjuster who thinks you're lying. That is coming up next on In Your Corner. Stick around.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-855-821-5900, or go to inyourcorner.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back to In Your Corner, mydisabilityquestions.com. That is another option for you to ask your questions anyway. We'll get to one here, guys, as we wrap up. Seth writes in, says, I've been trying new medications for my sciatica over the last year. My doctor said that I should have seen some improvement, but I haven't. My LTD case manager saw those notes and asked my doctor for his updated file. They accuse me of lying about my symptoms and will cut off my benefits next month. I'm terrified. I'm 49 years old and I can't go back to work. What do I do?
So again, this is something that I see quite often, unfortunately. Not that the insurance company accuses someone of lying, but that they take a position that because there's an ambiguity or a problem with the medical records, that somehow that reflects on whether or not the person is being truthful with them. And really, Seth, all you need to do is, first of all, it's a good thing that you called us now, because if you're getting cut off next month, we can intervene right now. Step in right now, take action right now against the insurance company. Don't wait. Secondly, go to your doctor, explain the situation, and have your doctor actually prepare a report that fleshes out the issues that the adjuster is talking about. And at the end of the day, if your doctor is supporting you and is saying that you cannot work, then the doctor, he or she, should be able to do that report for you. Give that to the adjuster. Explain in an email what your position is to the adjuster. This goes to James's point about making sure you document everything in writing. And again, get us involved right now. That's the key. Get us involved right now so we can step in.
Your doctor has final say. You got to have medical coverage, right?
Your doctor can have final say. They can overrule whatever the adjuster is saying from a medical standpoint, obviously. And again, remember, the insurance company is looking for any excuse to cut you off. Don't give them that excuse. We can hit back. And don't wait until you're cut off, because they will cut you off.
Done for another day, guys. Good stuff. You want to reach out, 1-855-821-5900. help@inyourcorner.ca is the email address you can use. And simply go to inyourcorner.ca for more details. We'll catch you next time right here on In Your Corner.